to you Kristen Anger, who is with Summit Law. And the presentation she's going to bring us today is called The Attendance Maze, Finding Your Way Through Family Medical Leave Laws. So Kristen, the floor is yours. Take it away. And we appreciate you being here.
Well, thank you for having me. Thank you for joining me for this rather daunting topic. I've been practicing employment law for over 20 years now, and I just find that managing employee leaves is one of the most challenging areas for employers. And so bear with me today as we try to kind of work our way through the different leave entitlements. And I want to kind of start by talking about why this is so challenging at the risk of mixing my metaphors here. I just talked about, the attendance maze is the title of this, and now we're looking at puzzle pieces, but both of them readily apply. It's a maze, it's a puzzle. And the reason I think that why these laws or why this area is so challenging for employers is reflected on this picture here. I think of leave laws as, my family used to go to a cabin and, we'd get out the games and the puzzles that they leave for you to play with, and you'd be working on a puzzle and you figure out eventually that this darn box has puzzle pieces from a bunch of different puzzles, and we're trying to make things fit together that weren't meant to go together. And that's how I think of leave laws, because when you look at each of these laws in isolation, it's like, oh, that makes sense. And that's good. And that's right. And that's fair. But then when you try to fit them all together, and when you add the overlay of your collective bargaining agreements or your personnel policies, it just becomes sometimes mind-numbing or overwhelming to try to make all of the moving parts fit. And sometimes they actually don't fit. So you're trying to kind of do the best you can to muddle through. I think many of you have probably already also found that these are well-intentioned laws. They're trying to support people in with legitimate family and medical needs. But we spend most of our time dealing with that small segment of the employee population that maybe isn't the intended beneficiary of some of these laws and are taking advantage of them. So we're going to talk a little bit about how to administer leave laws and make sure that you're fulfilling people's legal entitlements, but also trying to minimize some areas of abuse. I think another big challenge for employers is that these laws are a moving target. Just in the last several years, we've had new Washington paid sick leave law. We've had the new Washington paid family medical leave law. We've had the Families First Coronavirus Response Act. We've had the high risk worker proclamation and now statute in Washington. So kind of just when you get things straight in your mind, we've got a new leave law on the books. And so kind of adding to the mix makes it also very challenging. In terms of what I would like to cover today, we're going to definitely focus on kind of the two primary anchors for today's presentation, which is the federal FMLA, some key issues and kind of cases that have come up in the last several years to help us get a better handle on administering FMLA, and then the Washington paid family medical leave law. I would be remiss if I didn't also kind of mention some of the other leave laws that crop up when we're talking about family and or medical leave. So that would include the Washington paid sick leave law, because it affects sometimes how we operate, the Family Care Act, pregnancy disability leave under Washington law. And then we'll touch a little bit on ADA and Washington law against discrimination accommodation, which comes up when you're dealing with a medical leave. And then the HELSA law, which is the COVID-related kind of high-risk worker law. So we'll just touch on those briefly. I do invite questions. It's can be a little more challenging than if we were all in a room together, but you can input questions in the chat. Some folks will be monitoring that for me and interrupting me. If there's a question I can address in the moment. We're going to take a break about halfway through, so we'll have a 10-minute break, and before we go to break, and then maybe right after break and at the end, I can check the chat for additional questions that may come up. So please feel free to input that as we go. I think kind of what I hope will be very useful as we get through kind of the main leave laws. I'm going to spend a little time and have some slides that show how they fit together, different leave scenarios and how, these leaves might be integrated. And as you'll see, it can vary based on what the employee wants in terms of how the leaves unfold, whether they're consecutive or consecutive or at the same time. So you'll see kind of how they fit together, and I hope those slides will be pretty helpful as well. Okay, so we'll start with FMLA. These are, I appreciate challenging presentations to give because I know from having done it in the past that I may have some people who are not particularly familiar with the leave laws and others who could probably teach this class right with me. And so I'll start with kind of just to make sure we're on the page, kind of an overview of what the law requires, and then especially with the FMLA, since it's been around so long, some of the kind of issues that present challenges for us and new developments in this area. So as you probably know, the FMLA is kind of the mothership of leave laws, family medical leave laws, and it provides up to 12 weeks of leave per 12-month period. And it's very important for the employer to pick which 12-month period you're going to use. You can use a calendar year, you can use a kind of rolling look back or a forward-looking year. If you don't choose a year to use, then the employee gets the best one or the most advantageous one for their particular need, which is never a good place to be for an employer if you've got different leave years for different employees. FMLA is unpaid, as we'll talk about with Washington. Paid family medical leave, though employees can get access to financial benefits, but the FMLA itself is unpaid, although we do have to keep employees' health insurance intact. We can require that employees use their accrued leave in connection with an FMLA absence to avoid the kind of leave stacking. I think one thing that you'll hear me repeat this a little bit later is really to emphasize for employers and to make sure your managers and supervisors know this, that there can be no negative consequences for taking FMLA leave. It can be burdensome, it can be frustrating, but there can be no negative consequences. It's an absolute entitlement as long as somebody has leave on the books. And we're going to talk a little bit later, and you may be familiar with ADA accommodation, and maybe attendance is an essential function. And if you've got an employee who year after year takes 3 months off, they're not able to perform their essential functions, and this is an undue burden. None of that matters under FMLA. If they have hours available for FMLA, they get to take it, and your supervisors need to understand that. Once an individual runs out of, exhausts their annual FMLA entitlement, if they're out for a covered serious health condition, that may shift the conversation to, okay, if they need even more leave, we talk about reasonable accommodation under the ADA or the Washington Law Against Discrimination. So that's kind of a segue. And at least at that point, the employer can begin talking about essential functions and undue burden and undue hardship, those concepts. But again, none of that really matters when we talk about FMLA. I'm going to provide a number of links throughout the presentation to additional resources. There is a link there to U.S. Department of Labor FMLA guide. It's the employer guide. It's like about 75 pages of just very detailed guidance about FMLA. So if you kind of need to check a regulation or check a rule or check the definition of serious health condition, that's a great resource to just have in your office and at your fingertips. Okay, coverage for employers under the FMLA, only in private employers with at least 50 employees are covered. In the public sector, though, all public sector employers are covered. However, there's the catch there that if you are a public employer with fewer than 50 employees, as you can see, if you look at the employee eligibility, you may be a covered employer as a small public employer, but since an employee has to work at a location with at least 50 employees, you may have 0 eligible employees. So you have to put up the FMLA poster, but you're not ever going to have employees who are eligible because nobody works at a site with 50 plus employees. Other eligibility requirements for your employees: they have to have worked for you for at least 12 months, and they have to have worked 1,250 hours within the year, the 12-month period preceding their leave request. So unlike the ADA, where somebody walks in their first month of employment, they could request leave as a reasonable accommodation. They have that right from the get-go. FMLA, somebody has to have worked for us for at least 12 months. So reason to address kind of those chronic attendance issues during the first year of employment, because you can imagine it's only going to get more challenging to manage attendance once the individual becomes eligible for FMLA. Again, we're just covering some highlights on the basics under FMLA, qualifying events. We've got the traditional birth or adoption or foster placement of a new child with the employee's own serious health condition, which we'll talk about in a moment. Certain military related leaves have been incorporated under FMLA. Caring for a family member with a serious health condition is a covered reason under FMLA. And note that last bullet item there, because we're seeing more of this. When we talk about caring for a child with a serious health condition, that includes, or a parent, it includes someone who stands in loco parentis to that child, in the place of a parent. So we're seeing more non-traditional families, maybe a grandparent or an aunt functioning in a parental role. That aunt or grandparent could take FMLA leave for the ill child with a serious health condition. Or you may have employees, an employee who lives with a partner and that partner has children, but your employee functions in a parental role. That could support the right to FMLA leave. So just be mindful of those non-traditional relationships as well.
Hey, Kristen.
Yes.
Sorry to interrupt. We have a question.
Yes.
It's, can you clarify incapacitation and or disability for a child 18 plus years of age?
Yes. So for a child, an adult child who is 18 plus, the person has to be disabled and unable to engage in their daily care. I will tell you, as we'll get to under Washington paid family medical leave, there's no age limitation. So it's an adult child of any age, as long as they have a serious health condition. But for purposes of FMLA, they have to be incapacitated and unable to engage in kind of daily living activities. So if you have an adult child who is hospitalized, or you're bringing them home from the hospital, they're unable to take care of themselves. That would be an example where that would be covered. There's actually, I will mention too, in addition to the employer guide that I mentioned, the U.S. Department of Labor has really comprehensive set of fact sheets, and there is a fact sheet specifically on adult children. So if you need, if you find yourself kind of not sure of how to apply a particular rule, check the DOL FMLA fact sheets, because there may in fact be a guidance, and they're usually 1 to 2 pages, kind of quick hits, so that they do a good job, I think, of spelling out and providing guidance for employers. Okay, any other questions before I?
No,
okay.
No more questions. Thank you.
Okay. Serious health condition, again, is anything involving inpatient treatment. Chronic conditions, those are real popular. We see those a lot with the intermittent FMLA leave. So that's things like, a migraine, depression or anxiety, a back condition that flares up, those that require kind of occasional intermittent bouts of, FMLA leave. Anything pregnancy related, including prenatal appointments, those would be covered FMLA. Substance abuse treatment, that's where somebody goes in for some kind of inpatient rehabilitation program, potentially with some aftercare. And then this last one is important, and I'm going to come back to why it's important, but making sure supervisors understand. We often think of serious health condition as, somebody's in the hospital or somebody had a baby, but this last one crops up in a lot of situations where people might not think of a serious health condition. So it's more than 3 calendar days, ill or incapacitated, 1 visit to a healthcare provider, and a regimen of treatment, maybe antibiotics prescription or a prescription for physical therapy. So if our supervisors know that somebody has been out for more than 3 days and the employee mentions, yeah, I went to the doctor and got my prescription, I'll be back in a couple days. Ding, ding, that should trigger FMLA. Good segue to the notice requirements. FMLA is highly structured. There are all these forms that need to be kicked out on a certain timeline. So once we know that somebody's out for an FMLA covered reason, an employer is supposed to send this notice of rights and responsibilities. And these are all available, the link at the bottom, if you want to use the sample Department of Labor forms. Those have been updated in the last couple of years. So if you're using old forms, you might want to check out the new ones. But we have to kick out that notice. And sometimes there's a disconnect between the information that a supervisor has, and HR didn't know that somebody was out for an FMLA covered reason because it was just information shared with the supervisor. So there needs to be some mechanism to make sure that we are getting the information from our supervisors and know when to send out these forms. We have the right, as you know, probably the employee can be required to submit a medical certification showing that they have a serious health condition or that they're caring for a family member with a serious health condition. You can get a second or even a third second opinion or a third opinion if you have some reason to doubt the employee's certification. I don't see employers using this option all that often. It's when you have a red flag, right? When somebody's facing, I don't know, discipline or investigation, and suddenly they have to take FMLA leave, and you're like, this is fishy. Or they were requesting vacation, right? And they couldn't get a vacation approved, and you heard they already bought their tickets to Hawaii, and suddenly they submit an FMLA leave request. So it might be those situations where it's actually worth, but because you have to send them to a doctor, you have to pay the costs. So it can be kind of a cumbersome process, but it may be worth doing under particular circumstances. And then very critically, the employer has to issue a designation notice. We are designating this absence as FMLA. That is what starts the clock. We're never going to run out of FMLA and talk about undue hardship if you never start the clock. And I can't tell you how often it happens that I'll be talking to a client about this leave problem, and they never started FMLA. The employee never requested it. The employee had sick leave, so we never bothered. We never got that clock running, and now we're starting at ground zero because there is a mechanism for retroactively designating FMLA, but it's more challenging to show that it's justified, and I wouldn't recommend it. It's better to designate it as soon as you know the leave is covered by FMLA. Okay, very common question that comes up, and I want to spend a couple minutes talking about this, is what if our employee does not want FMLA? Right? They may have collective bargaining rights. And so they're like, no, I just want to use my leave under the contract. Or no, I have accrued leave bank. I just want to use this. I don't want to use my FMLA. Maybe I want to save it for later, right? Well, if you've been to leave law trainings in the last 5 years, you probably heard reference to this case, Escriba, which was, horrible for employers. It was issued in 2014. We used to have this mantra of, start the clock, get that FMLA clock running, even if the employee doesn't want it. Again, because you're never going to run out if you don't get that clock going. So then Escriba comes along, and it's a Ninth Circuit case. Ninth Circuit is the federal appellate court that has jurisdiction over the Western United States, including Washington. And basically, it's just so frustrating because the court actually ruled in the employer's favor, but the case involved an employee had gone off to, I think, Guatemala to care for her ill parent. And the employer said, do you want FMLA? And the employee said, oh, no, I've got vacation. I'll be back in 2 weeks. I don't want FMLA. So she left and went and took care of her family member, didn't come back after 2 weeks, didn't come back after 3 weeks. And the employer said, this is job abandonment, and we're going to, terminate and move forward and filling that position. So then the employee or former employee came back and sued and said, you violated my FMLA rights. And the employer's like, what? You specifically said you didn't want FMLA. And the court thought perhaps it was doing the employer a favor and said, yes, the employee can't basically have their cake and eat it too. They can't say, I don't want FMLA, and then turn around and sue for it. That sounds right? But the problem was the court went on to say, an employee might have a reason, to decline FMLA. Maybe they want to save it for later. And we were all like, no, that's not, that's not helpful, Judge. So we now have this Escriba case that's been around for, again, since 2014. The U.S. Department of Labor has repeatedly come out and said, that case is wrong. We administer this law. We don't agree with that interpretation, but we're in the Ninth Circuit. We're kind of stuck with it. So as you can see, I've got references here to two 2019 U.S. Department of Labor opinion letters that very clearly say, if an employer is aware that somebody's out for an FMLA covered reason, the employer must designate it as FMLA, and the employee can't decline FMLA. And as you can also see, the new FMLA designation notice issued by Department of Labor includes very clear, included the entire quote there that says, once somebody's out for FMLA qualifying reason, an employee cannot, or an employer may not delay designating such leave as FMLA, and neither the employee nor the employer may decline FMLA protection. So very clearly conflicts with the Escriva holding. What do we do when we have a conflict between a court and a federal agency who interprets and enforces that rule? It's a little tricky. Ultimately, courts have more authority. We all, though, think that the Ninth Circuit didn't quite realize what it was doing in the context it issued that ruling. And if this issue came up again, the Ninth Circuit would go, oh, yeah, actually, here's what we meant to do. So we're in a bit of a, it's just a little messy right now and a little uncertain. And so I think that until we get another case, the options for further guidance is if you really just want no risk whatsoever, just let the employee decide. I mean, if you let them decline FMLA, who's going to complain about that, right? So that's one option if you're really risk averse. Although, I guess at some point the U.S. Department of Labor could come knocking and saying, you're not following our guidance. I'm not sure who would bring them to our door under those circumstances, but it's an option. I think the more common or increasingly common approach is employers are feeling more and more confident with the Department of Labor rule to say, we're going to designate this absence as FMLA, even if you don't want it, because that's what this federal agency is clearly telling us to do. I think a good middle ground, if you're risk averse, is to go ahead and just as a matter of course, issue the designation notice. But if somebody really pushes back and even goes so far as to say, Escriva, then you might say, okay, we will go ahead. You put it in writing that you don't want FMLA. We will follow your request in this particular circumstance, but we will continue designating FMLA leave as a matter of course. That avoids that person making a claim, and it tries to comply with the DOL guidance. So I think that's probably a good middle ground for employers that want to follow what we think is the best practice, but without any likely risk of liability. Another issue that's really cropping up quite a bit lately is whether an employee can say, here's my FMLA certification, I can't work overtime, or I can only work 35 hours a week or 32 hours a week, because if I work more, I will become symptomatic or I will become incapacitated. I would say for years, we interpreted FMLA as saying, no, you have to be actually incapacitated. It covers periods where you're unable to work, not gives you reduced hours to avoid becoming, unable to work. Well, this case cited here, Santiago versus Department of Transportation, really underscored that an employee can, in fact, use FMLA as the court's word was, as prophylactic leave, meaning you can say, the doctor can say, this employee needs to not ever work mandatory overtime or not ever work more than 40 hours in a week or 32 hours, more than 32 hours in a week to avoid getting symptomatic. And so in this particular fact pattern, it was an employee whose doctor said any hours over 40 in a week, he would get migraines or would increase the likelihood of migraines. And so that was recognized as an appropriate use of FMLA leave. So I think as a result of that, it really it creates challenges, especially for those employers like 911 dispatch centers with minimum staffing requirements. You have to have a person in every seat to meet the community's needs. And so you have mandatory overtime to help cover that. And if you've got, some of our poor clients have multiple people who are playing this game and are having FMLA certifications that prevent them from working mandatory overtime. So then the overtime falls on the shoulders of, the remaining employee group. So it creates lots of challenges in meeting those minimum staffing requirements. But as you can see, this is an area where I think FMLA has been expanded in recent years, and word is on the street that if you don't want to work overtime, go get an FMLA certification to that effect. I think intermittent leave under the FMLA is probably one of the biggest headaches. And so I wanted to spend a couple minutes just talking about kind of what tools in your toolbox are there to kind of curb intermittent leave abuse. And I want to reiterate, I'm not suggesting that people don't take FMLA intermittently for really legitimate reasons. That is absolutely the case. That's what it's there for. But I do deal with clients that are suspicious around an employee's use of intermittent leave. Some people call it the Friday, Monday Leave Act because somebody gets certified, right, for an intermittent flare-up condition. And curiously, all of their absences fall on Fridays and Mondays or sunny days, et cetera. So what do we do, or what options do we have when someone is calling in kind of intermittently? It's putting a burden on your operations and you're suspicious. Well, I think just kind of a little checklist here to use. One is absolutely to make sure that that original certification is valid and sufficient. I often talk to clients who are frustrated about a leave matter after it's been underway for some amount of time and it's really becoming operationally burdensome. And I look at the certification, I'm like, this doesn't even make sense. It's incomplete. It wasn't signed. Whatever. The person wasn't eligible. So make sure, again, right out of the gate that this person at least does the base minimum to justify the need for leave. There are going to be times when you want to get a second or third opinion around that. It's important to note with the second, third opinion, that can only be required with an initial certification. So we can't do it like 8 months into somebody's leave usage where we start to see, questionable patterns. We have to do it at the outset. Or you can do it in a new leave year. Like once somebody goes into the next leave year, you can get a new medical certification. That's not a recertification at that point. So you could get a second or third opinion at that point. Absolutely making sure that all absences that are covered by FMLA are tracked and designated. Again, no one's going to run out if we're not at a minimum counting each absence towards their total entitlement. You can certainly require, and your supervisor should understand, you can require compliance with your leave or your call-in and your notice requirements. FMLA isn't a free pass to come and go as somebody pleases, so you can hold people accountable. And we had an arbitrator uphold a termination of an employee who just no-showed and said, well, it was FMLA. Well, that doesn't change the fact that you've violated a rule. We're going to come back to that in a little bit, just because there are some kind of cautions there as well. If somebody's taking FMLA intermittently for planned medical treatment, you can transfer them to an equivalent position, or at least require them to schedule that at times that don't disrupt your operations unduly. You can only require that they make a reasonable effort to do so. So if they say, this is the only appointment time I could get, not much we can do. Note that these options are only when somebody is taking intermittently for planned medical treatment. If they're having flare-ups, unfortunately, the statute does not allow the transfer to an equivalent position. So that's a frustration under the FMLA, but it is what it is. Another option for you is good old, kind of gumshoe detective work, potentially hiring an investigator, or just, seeing what people are up to on social media. And there are, limitations on employer access to social media, but sometimes, other employees come forward. We had a situation in our office where an employee was certified for a back condition. And she called in for FMLA, yeah, I can't get out of bed today. My back went out. And other employees who were frustrated by her frequent absences came in and said, have you seen her Facebook page? She's like in this ninja competition where it's like this iron triathlete kind of thing where she's crawling under barbed wire and in the mud. And, it's this very physically demanding competition on a day that she'd called in for FMLA. Well, she was terminated and the termination was upheld. So that, when you catch somebody kind of red-handed doing something like that, that would be a form of misconduct. And the fact that she had an FMLA certification does not protect her from that. Requiring recertification is also something you can do if somebody's using leave in excess of what was certified, or circumstances have changed that call into question their entitlement to leave. And then, as I mentioned, when somebody goes into a new leave year, that triggers your ability to request a new certification, a new medical certification. And then what you can do with that is at that point request a second opinion. So those are some of the options we have here. Then I want to circle back because I just gave you some tools to address intermittent abuse, but there are some limitations that I just want to caution folks about based on cases that have come out in recent years. One is when I said you can catch people doing stuff that's inconsistent with their FMLA certification. Not all personal activities like a vacation are necessarily inconsistent with the reason somebody is taking FMLA leave. So this DePrado case illustrates that well, and came with a big penalty, as you can see, $1.3 million in damages plus attorney's fees. And it involved an employee who had foot surgery, and he was going to be out for like 6 weeks. And during the last couple of weeks that he was out, people saw on his social media that he was actually in Mexico. And so the employer kind of very quickly decided to terminate his employment because he was abusing FMLA leave, clearly going on a vacation to Mexico. And the court said, you know what, this is an FMLA violation because the employer didn't take the time to really investigate and look at whether his trip to Mexico was really inconsistent. He, by the time of trial, was saying, I was there, I was on crutches, and, I could put my foot up. And so as you can see, the court's language there, vacationing on FMLA could be either permissible or impermissible, depending on the employee's illness, or injury, and what they're doing on vacation. So just be cautious about, assuming that anything, leaving your house is somehow illustrates FMLA abuse. We need to make sure that what the employee is doing is actually inconsistent with certification. So certainly with certain physical kinds of FMLA, serious health conditions, it might be easier to show that. I think mental health ones could be challenging. Somebody with depression or anxiety, maybe their provider says you should take some time off and relax and go somewhere and get away. That's part of your treatment. That wouldn't necessarily be a basis to terminate or discipline. One other I did include at the bottom there, as you can see, the bullet item about you can have a uniform policy prohibiting outside employment during FMLA. So that is an appropriate thing to do. So just be careful on those. Another kind of red flag or cautionary tale that I want to say, I told you in your toolkit, right, that for curbing intermittent abuse, you can require compliance with your call-in requirements. And that's fair. You can discipline somebody, as you can see from the first case cited there, the Delta case, that even when somebody is out for an FMLA covered reason, they can be disciplined for not following the call-in or notification rules around an absence. However, don't be overly rigid, as that second case reflects. Again, another, this time $500,000 verdict, where an employer had, the requirement that you have to call in and you have to speak directly to your supervisor. Well, this employee had been hospitalized for mental health issues. Her son called to let them know she was hospitalized, and he said that he had been in contact with his mom daily, and she was doing okay, but she was still in the hospital. And after 3 days, the employer terminated her because she didn't call her supervisor directly per the policy. And the facts came out that, she was, yes, the son was in contact, but she wasn't very coherent, and they had kind of pulled the trigger very quickly on a termination on a kind of a technicality. So in all of these, we don't want to kind of rest on technicalities. You want to kind of make sure that we're being compassionate, that we're fully kind of considering what the fact patterns are. Certainly where there's clear abuse, there may be a basis to terminate. But, we also don't want to be so rigid and so structured that we look kind of inhumane, basically. Another theme that I kind of have already alluded to is please make sure, I know leave can be overwhelming to supervisors, and HR generally handles leave administration, but supervisors really need to at least understand kind of notice obligations, and then making sure that they are not taking protected leave into account when they are implementing, when they're disciplining or managing performance issues, things like that. So I included a couple cases here illustrating how, in the words of the first bullet there, supervisors can snatch defeat from the jaws of victory. Both of these cases referenced here involve situations where there was such a clear basis for terminating a couple of employees. The first one in the Hefty case, this employee, oh my gosh, you should read the case. It's like, this guy was such a jerk. He brought his wife into work and he introduced her as his bitch. He referred to another coworker as his BITCH. He was counseled about in his review about his conflicts with other employees. And, he wrote back and said something like, I was just defending myself to that stupid idiot and take this nonsense out of my review. He just sounded like unmanageable, basically. Such a clear basis to terminate, they discipline him, and they were headed towards termination. Unfortunately, as luck would have it, 3 weeks before they actually made that decision, he had requested some intermittent leave to take his son to some medical appointments. Pretty low level, minimal amount of leave. Unfortunately, the supervisor responded, we pay for your insurance and we expect you to be at work. That was the response to the request for FMLA leave. Well, that resulted in the court not dismissing that case, despite the very, very clear basis for, legitimate termination grounds, because the supervisor had signaled this, resistance and frustration around the employee's request for FMLA leave. Similarly, I won't spend a lot of time getting into the details, but the Stewart case, very, very clear example where the employee was not meeting expectations. She was in the banking industry. So it was like objective number stuff, like showing that she was not meeting expectations compared to her peers. And the employer, she took an FMLA leave. The employer, a couple of weeks or months after she comes back, the supervisor writes this memo about, recommend termination because blah, 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 all the statistics about her performance. And then he adds, and because she took medical leave recently. What? Court didn't dismiss it because that suggested that was part of the reason, and that was impermissible. So it just is so imperative to make sure that your supervisors, if you can scrub those documents before they, get finalized, or just make sure that supervisors know that those factors have no bearing on any kind of employment decisions that you would be making. Another kind of training flavor is making sure that your supervisors have their eyes and ears open. If somebody is requesting FMLA leave, again, that triggers the notice obligations. But take a look at this case. This one is nuanced and it's challenging for a lot of supervisors. So we had an employee who was really very, respected employee, had done good work, but her performance dropped off significantly. She was crying uncontrollably at work. She told her supervisor that she couldn't sleep, she was feeling overwhelmed, she couldn't eat, and asked, this was at a school, can I go to a 10-month position instead of a 12-month? And the supervisor said, no. Okay, issues continue. The employee is still doing terribly, crying openly at work. The supervisor says something like, you need to just decide whether you're staying or going. And the employee felt pressure, and so she resigned, tried to retract her resignation. The supervisor said, nope. And so she ended up suing. No big surprise. She's diagnosed with a range of mental health issues. And the court said, you know what? That supervisor should have known this employee needed leave. She didn't have to say FMLA, should have told her that these were options available to her. So this is, I say this is kind of a tough one because it's challenging. We tell supervisors, focus on the behavior, focus on the performance. Don't, assume somebody has a health issue until they tell you that. But when somebody's actually telling you of symptoms, I can't sleep, I can't eat, I'm crying, being humane and making sure that they have the resources, at least getting them to human resources to go over the options available. Because if we don't, and we just go ahead and say, okay, you're out the door, obviously, in this case, the employer ended up having to litigate, and the case wasn't dismissed because the court said the employer had constructive notice that this employee needed job protected leave. So again, just another investment in our supervisors to make sure they understand, what they need to be paying attention to. Another common question that I get is, and it comes from the inevitable fact pattern of, you just got a complaint, you need to initiate a personnel investigation, or you're just ready to impose discipline on somebody, and suddenly you get their FMLA leave request, and suddenly they're unavailable to you, and so you can't investigate or you can't proceed with your discipline. Can we go ahead? And this case suggests that yes, within reason, an employer can proceed with its normal normal course without interfering with an FMLA, an employee's FMLA rights. So this one involved an employee who, it was a school situation. The employee was involved in some kind of physical altercation with a student. There was an investigation that was done. The employee claimed, a great amount of stress and took FMLA leave. And during the FMLA leave, the employer required the second opinion and made the employee attend a disciplinary conference. He later sued and said that interfered with his FMLA rights. And the court said, no, the employer had the right to get a second opinion, and it had a reason to complete that investigation and address the disciplinary consequences. It was just a meeting. It wasn't that big a deal. It didn't really impact his ability to take leave. I will caution that under the facts of the case, the employee at the time of the disciplinary meeting didn't object or request that it be delayed. So that's an important consideration if there's a request that it be delayed. But the court also had some really good language about, an employer has an interest in completing its processes and shouldn't have to just sit and hold everything in abeyance until the employee becomes available, especially when it's kind of a reasonable and minimal intrusion on their leave. So, again, not kind of a black and white rule about what we can do, but there is potentially an option to ask somebody to participate in an investigation or meet to have a disciplinary meeting during a leave of absence. Okay, I want to start getting into some of the Washington leave entitlements. That was kind of our quick tour through FMLA, but let me know if you do have any questions about FMLA. The Washington State leave entitlements that I want to touch on in the next remaining time is the Washington paid sick leave law, pregnancy and childbirth disability law in Washington, our Family Care Act, and our Washington paid family medical leave. There used to be a Washington Family Leave Act, and that one was repealed, so it was replaced by the Paid Family Medical Leave Act. We're also going to, again, touch on very briefly disability accommodation and the high-risk worker laws. I want to take a moment also to emphasize I'm focusing on the laws. You all definitely need to know what's in your labor agreements, what's in your personnel policies, especially in the public sector. They often go beyond even what the law requires. And so, that might be an additional consideration that you have to fit in, unfortunately, on top of all of these. But again, I can't get into all of those because I don't know what your individual policies say. Okay, Washington paid sick leave. We'll take a break here in probably the next 10 minutes. Washington paid sick leave was a law, as you may know, took effect in 2018. So we've had it around for a few years now. It really, I think for a lot of public employers, we were kind of like, it won't make that big a difference because we already provide more generous leave entitlements than this new state law really affords. As you can see, it amounts to only, it's only about 6.5 days per year of accrued sick leave, assuming a 40-hour work week, and because you accrue 1 hour for every 40 hours work. So yeah, our sick leave law or policy is already more generous. So this shouldn't really impact us. Well, it does impact employers in certain ways because it forced some employers to broaden their coverage of their sick leave policies or labor contract provisions and the way we administer sick leave. So I just wanted to at least touch on that and make sure that you're in compliance with these state requirements. I think a big issue that you probably already made this decision at some point along the way when this law took effect, do we create, I use the term buckets, do we create a Washington paid sick leave bucket and then have our city, county, library, district, whatever, accrued sick leave in a separate bucket and we have different rules for each of them, or do we throw everything into one bucket? If you've thrown everything into one bucket, then you have to follow these rules with respect to the entire bigger bucket. So that's important. In terms of kind of the changes that employers need to make sure they made with the Washington paid sick leave on the books is the covered absences is very broad, almost certainly broader than what most employers' existing sick leave policies included. So it's an employee's own illness, the illness or health condition of a broad list of family members. As you can see, child, parent, grandchild. I joke that I can take my 50-something year-old brother to get a flu shot that. And, that's covered by the sick leave law. It's even adult siblings. School and daycare closed for health reasons. We saw that during the pandemic. And then any absences covered by the domestic violence leave law. So much broader, includes preventive, like if you had an old policy that said, you have to make planned dental appointments or planned medical appointments outside of work hours. Can't do that. That's a covered reason for taking paid sick leave. I think one of the biggest things is absolutely no doctor's note required until somebody's been out for more than 3 days, even when it's totally suspicious, right? I need Friday off because we have tickets to, blah, blah, blah. I'm sorry, I can't get you that. I'm calling in sick. We can't require a doctor's note in that situation, even if it's highly suspicious, and supervisors really need to be aware of that, and be aware that that's the law, even if your collective bargaining agreement or personnel policy says otherwise. Another policy thing to check is under the Washington paid sick leave law, it's 1 hour of paid sick leave accrual for every 40 hours worked. You cannot have a cap on accrual. A lot of existing policies said, up to 800 hours, and then you stop accruing, until you come below that. Can't do that anymore. So if you have one of those old-fashioned policies, that should be revisited. What you can do is put a cap on how much they carry over from 1 year to the next. So check your policies on that. Another big one is making sure that you don't have any incentives in place that reward people for not using accrued Washington paid sick leave. So some kind of additional leave day or monetary bonus if they don't use sick leave, that's going to be problematic. That was frustrating to a lot of unions who really liked, those kinds of incentives, those little extra rewards, but they really needed to be scrubbed from contracts and policies. One kind of issue that wasn't necessarily on people's radar that we saw after the Washington paid sick leave law came out deals with the interplay between Washington paid sick leave and the Family Medical Leave Act. So as you probably know historically, and your policy probably says, during FMLA, we require that you use any accrued leave available to you. And the idea here is to prevent stacking, first FMLA, then they save their accrued leave for later. So we, increase the total duration of leave. So in order to avoid that, we would compel employees, which the FMLA says we can, to use accrued leave during an FMLA. Well, when the paid sick leave law was passed in Washington State, Department of Labor and Industry has adopted an administrative guidance that says, no, you cannot tell an employee that they have to use Washington paid sick leave. They can just take an unpaid leave of absence under FMLA, but you can't tell them they have to use paid sick leave. So that is something that you may want to revisit in your policy. I think it's fine to have a default, like the default will be that we will first apply, paid sick leave, then any vacation. You can require vacation, by the way, but this Washington paid sick leave is up to the employee. And so if they elect not to use it, we can't compel that. We did try to fight with L&I over that and said it's inconsistent with the FMLA statute itself, but they didn't buy that. And so we do have this administrative policy saying that you can't do that. So might want to check your policies on that. Okay, let me touch on this slide and then I'll see if there are any questions, and then we'll do our break. This pregnancy childbirth disability leave is just it's not of a specified duration. It just says under Washington state law, if a female is disabled temporarily due to pregnancy or childbirth, so put on bed rest pre-birth or following birth, 6 to 8 weeks presumptively disabled, that is protected leave. Even if that, it happened their first day of employment, there's no eligibility requirements like there is for FMLA or PFML, as we'll talk about. So we want to make sure that, we're observing that if somebody it doesn't really come up that much unless somebody is not eligible for FMLA and PFML. And so this would be their only source of protection. It's unpaid. Health insurance isn't necessarily maintained unless they're using maybe accrued leave, but it should be on your radar. And as you'll see when I start showing you the different timelines, how it crops up. Okay, so let me check on questions. Oops, and then we'll come back here. Okay. Oh boy. Okay, let me.
Kristen, this is Janae. Sorry to interrupt you. So we've got two different sets of questions going on.
Okay.
We have the Q&A in Whova, so that might be what you are able to see. And then we also have a Q&A in Zoom. So when it comes to the Q&A in Whova, we're just going to send those to you after the meeting to answer, if that's okay. But for now, I'll go ahead and relay the questions in Zoom if that works for you.
Okay, yeah, I can only access the ones in Zoom. So that's great. And I think what probably makes the most sense is let's go ahead and take our break now. And when I come back in 10 minutes, I will have had a chance to look at the questions and I can probably be a little more efficient in answering them.
Sounds great.
Okay, so my clock says 2:08. So let's come back at 2:18 and I'll see you then.
All right. Thank you, Kristen. We'll be back at 2:18 and pick it back up.
About that, everybody. Sorry about those of you who have lost your internet. Yeah, I can definitely see the chat that comes in through Zoom. So I'll run through these questions. I'll do it as quickly as I can in recognition that we still have a lot of materials to get through, but I can, oh my gosh, why is it jumping around? Okay. Well,
thank you, Kristen.
Is somebody else touching the, I don't know why this is jumping around, but okay. On the questions, somebody asked, what if an employee needs to take care of an eligible family member located in a different country? That would be potentially covered. I think the documentation could be more challenging. You're still entitled to the medical certification from the family member's provider, but yes, that could potentially be covered. There was also a question above that about a grandparent taking care of the daughter, going to the birth of the grandchild to help their daughter after birth. Under FMLA, they would have to show that the adult daughter is incapable of self-care because of a serious health condition. So the doctor would have to establish that. As we'll talk about with Washington paid family medical leave, that as long as the daughter has a quote serious health condition, which is some period of incapacity following inpatient treatment, having a baby usually in a hospital, that would be covered. So it's not to care for the grandchild. They need to at least represent that they're there caring for their child under FMLA. PFML, you can care for a child as long as the child has a serious health condition. Okay, a grandchild, sorry. Do employers need to send out the responsibility notice if an employee does not yet qualify for FMLA? Yes, as you'll see, like from the rights and responsibilities notice, there's actually a box that you say you are eligible or you are not eligible. And here's why you're not eligible. So you would check the box that you're not eligible because you haven't worked here a year or you haven't met the 1,250-hour threshold. Are employers still under a requirement if they're aware of FMLA eligibility to put employee on FMLA and an employee doesn't want to use FMLA? I think we talked about that with the Escriba, that's kind of we're on a bit of kind of quicksand there because of the conflict between the Department of Labor and the Escriba court case. That is really an employer's decision to make whether you're going to go ahead and designate an absence as FMLA if the employee doesn't want to. I think you have the authority to under the Department of Labor guidance if you want to. More questions. What about COVID with FMLA? There's going to be a slide on that a little bit later, but I'll just briefly mention now some COVID absences could be covered by FMLA if it meets the definition of serious health condition. Somebody's hospitalized or they have more than 3 days ill or incapacitated and some kind of regimen of treatment like a prescription. Some COVID is just like stay home and isolate. That might not be a serious health condition. So it's really going to depend on the circumstances. Can an employer designate leave as FMLA if the employee does not return the provider certification to document the need for leave? That's one of those tough situations where if the employee is saying, no, I don't want FMLA, and you are saying we want to designate it as FMLA, and then the employee won't return the medical certification. You have the right to a medical certification, but you don't have to exercise that right. So if you know somebody's out, like they were hospitalized or they are hospitalized, that you could designate that as FMLA without even requiring a medical certification. So that would be up to you. If you're not sure, I think that's the tricky thing is you don't know for sure why somebody's out. They're saying they're sick, but you're not sure it rises to the level of a serious health condition. So that would be a kind of case by case basis. The PowerPoint will be mailed. A couple more. If bylaws state they honor FMLA, do you know if they are to follow the same tracking rules and notices, or can they just keep track of leave? I think that's just that becomes a contractual question. Do the bylaws amount to an enforceable contractual right? I mean, I certainly, even if you say we provide an FMLA-like benefit, I would try to include language or modify your bylaws to not, fully adopt the FMLA, but say you will follow your own, you'll provide an equivalent benefit subject to your own notice requirements and related requirements, so that you're not subject, you don't make yourself subject to some of these onerous things, but that would be by contract versus by law. And you're in control of your bylaws. So I would think that you could address those to commit to the things that you want to do without some of the more onerous things. So can you cap a carryover each year if your sick leave accrual per month? Gosh, why is it doing this? If your sick leave accrual per month is over the 1 hour per 40. Yes, you can set an annual cap on carryover. You can set it at 80, you can set it at 100, you could set it, you have to allow at least 40 hours to be carried over from one year to the next. And you can cap that carryover, if you have a high number, if you've had a total cap of like 500 hours, you could say 500 hours is our annual cap, and anything over that would be gone. So yes, you could definitely do that. Question, what about payout of 10% of unused sick leave at resignation and 25% sick leave payout at retirement? Those cash outs upon separation or annually are okay. So I'm glad these questions were raised because I said no incentives, but technically, I mean, these cash outs, they are kind of an incentive because they incent people to kind of preserve that cash by not using their sick leave. As long as you do it at termination or on an annual basis, so not kind of cashing things out as you go or having multiple quarters where you can cash out, that's okay. So that's not an impermissible incentive. And I think that covers 2 of these questions, because there's a question about a union contract. I am not saying this is no longer legal. You can continue to do that as long as it's a cash out on an annual or end of employment basis. Okay, there has been some confusion on letting people use sick leave. Example, employees using leave to accrue overtime. Are you able to ask them not to use sick leave for that reason, or do you have to let it be? I'm not quite sure I'm following this question. I'm going to assume that the question is, if somebody is scheduled to work overtime and they call in sick, they're entitled to use their Washington paid sick leave to cover that. I think messier ones were happening where it's like voluntary overtime and somebody says, I'll take it, but I want to use my sick leave. So they never had any intention of working it and it wasn't scheduled. That would not be a situation where you would have to let them use sick leave. But if it's scheduled overtime or mandatory overtime and they call in sick, they should be entitled to get the compensation for that by using Washington paid sick leave. Can you clarify that employers who do not separate paid sick leave from PTO accrual, then PSL rules apply to all PTO accrued hours? Yep, that's true. If you are a PTO employer, so you have this one bucket of sick and vacation, that's permissible under Washington paid sick leave. But when somebody is using that PTO for a Washington paid sick leave covered reason, then you have to follow the Washington paid sick leave rules. So that's kind of a downside to using that single bucket. Okay, so with that, let's get back to the slideshow. Very briefly, the Washington Family Care Act, I just wanted to kind of have this on the list of family care leave. We still have this, and it basically allows an employee to use their choice of any kind of accrued leave that they have, holiday, pay, floating holiday, comp time, sick leave, vacation, to care for certain family members under certain conditions. So this slide shows kind of what they can use. This law was around before Washington paid sick leave. I think it's less relevant now, although it is important because somebody could say, no, I want to use my vacation for this one, or I want to use my floating holiday to stay home with my child. And you couldn't force them to use a different kind of leave if it was family care covered. We're getting into these state laws where there are state resources available. So there's a pretty comprehensive frequently asked question document with a link there on the Family Care Act if you get into kind of a unique Family Care Act question. Oh, why is this doing this. I'm so sorry. I don't know why it's jumping around like this. Okay. I want to talk about the Washington Paid Family Medical Leave Act. This is another thing where, I don't know how familiar folks are with it. So I'm going to go through very quickly through some slides that just give you the basic parameters of it. But I know I'm kind of skipping over it fast, but I'm assuming since this law has been around for a couple of years, people are generally familiar with the basic requirements. So let's talk briefly about employee eligibility. And I do think this is important to emphasize. I think there continues to be a lot of, especially on the employee side, confusion about eligibility, because there are two different eligibility standards. One for whether somebody is eligible for monetary benefits from the state. And as you can see, that only requires that somebody work in the state for 820 hours in the last qualifying period, basically the last year. So somebody doesn't even have to work for you for 10 hours. As long as they worked in the state for 820 hours, they could apply to the state and get these monetary benefits. Different eligibility standard for whether you as the employer have to provide protected leave. For that to apply, somebody has to have worked for you for 12 months and have worked 1,250 hours. So those FMLA eligibility standards are important. And I don't think that the state website is very clear about this. And so, it creates a lot of confusion. Employees go, well, I got my approval letter from the state, so I'm entitled to leave. No, you're entitled to financial benefits. You're not necessarily entitled to protected leave. So you as the employer still get to decide whether, in that situation where they're not eligible for protected leave, whether you're going to grant protected leave in that circumstance. There is, did I skip a slide? I'm so sorry. It's being really sensitive for some reason. If you have, I swear, if you have small employers out there that's under 50, or in some cases under 150, there are some special rules for smaller employers. You're not necessarily entitled to or obligated to grant protected leave if you have fewer than 50 employees. You don't necessarily have to pay the employer share of the Washington Paid Family Leave premiums. But if you do, as you can see from the bottom half of this slide, if you do pay those premiums, you can be eligible for some grants when you allow employees to take paid family medical leave. So $1,000, $3,000, depending on the circumstance. So if you're a small employer, you might want to check those out. Oh my gosh, you guys, I'm so sorry. I'm not sure what is happening with this. Okay, benefit administration. Oh, okay, I'm going to try to do something different here. Okay, I hope this helps. I apologize. Benefit administration, again, this is unlike FMLA where you're administering it yourself. The state really kind of is behind the scenes running this program. And so an employee has to file a claim with the state, the Employment Security Department. Employment Security Department sends us a notice, and we can respond, we can try to appeal. My experience, it's kind of been a black hole. Once a claim is filed, it's hard to get details from ESD about the status of leaves and approvals, et cetera. But this is the process. The important decision point for employers is, are we going to allow our employees to supplement the state benefit with accrued leave? You don't have to allow this. You can allow it. I think many of us were like, well, why wouldn't we allow that? The reality is it just because it's not transparent when people are using leave, it can be kind of administratively burdensome to figure out how to manage that supplementation. So I think most of our clients said no supplementation out of the gate. We'll see, how this works before we start committing to that. But some of you may be doing this, smaller employers with fewer leave requests to manage. It may not be very burdensome, but that is an option that is left to the employer's discretion, potentially subject to bargaining. Like FMLA, there are notice requirements. Make sure that when an employee is requesting leave covered by PFML, that we're giving them these notices. You should have a poster in your workplace. Then there's, like FMLA, kind of this notice of your rights to take PFML. So there are links to both forms of required notices. And this is another area where your supervisors need to have their eyes and ears open, because they may learn that an employee is needing or requesting leave before HR does, and that triggers these notice obligations. Employees have notice obligations too. They look and smell a lot like what we see under the FMLA. They have to give us 30 days advance notice of foreseeable leave, otherwise just notice as soon as practicable. Notice can be written, but it can be a text or an email. So we can't necessarily compel them to use a particular form. They're supposed to give us at least the anticipated timing and duration of the leave. And ESD is supposed to actually deny benefits if the employee doesn't establish that they gave the employer notice. That last question, can we require an employee to tell us each time they take PFML? The statute doesn't address it, but I would say, yeah, because we need to make sure that we're honoring your rights to protected leave. So I think it's eminently reasonable to say you need to tell us, just like with FMLA, each time you are taking leave for this covered reason. I think what's a challenge under PFML is the certification comes from the ESD, and it'll just say this employee has been approved for intermittent leave between now and the next 6 months. But unlike FMLA, where we have the doctor's certification that says, oh, it's going to be 2 times a month, 3 days per episode, we don't get that. So the employee needs to tell us if they're out for a PFML covered reason, this is PFML, this is covered, so that we can ensure the leave is protected appropriately. Benefit amounts, the good news is you don't have to do the math. The state does this. I just included this slide to give you a sense of what PFML benefits look like. If you haven't seen what the dollars look like, there's a weekly cap that is adjusted annually for inflation. So for 2022, that is a little over $1,300 a week maximum. So again, if you have employees whose weekly earnings are over that, you have to decide whether you're going to allow them to supplement, to top off, to get up to full pay using accrued leave. Obviously, the weekly benefit is going to be prorated. If they only took 2 days, for example, they're going to get 40% of the weekly benefit. I mentioned the maximum, but their normal weekly wage dictates the actual, benefit payment up to that maximum. So somebody whose weekly earnings are reduced, you can see kind of what the corresponding PFML benefit would be. So that gives you a sense of what the benefit amounts are. Covered reasons. This is one of the areas where PFML looks a little like FMLA, but there are absolutely differences. So medical leave includes, leave for the employee's own serious health condition, and the definition is the same as for FMLA, unless the employee is on workers' comp. So workers' comp injury, that's going to be covered by FMLA, right? It's usually a serious health condition if they can't work, but they can't also get PFML because they can't get double benefits from the state. So definitely serious health condition unless they're getting workers' comp. Then we get into the family care, and that's where the state law is broader. As you can see, a child, regardless of age, so that 18 and over or 18 and under cap is inapplicable under PFML. Grandchildren, grandparents, siblings, step-parents, stepkids, and then I added the italicized. That's a newer add-on to the PFML, amendment to the PFML. A person for whom there's an expectation that the employee will provide care. So you could have an aunt, a family friend, somebody who expects that this employee to provide care. That could be a covered reason under PFML. Also includes bonding time under PFML. And here's a big one. Bonding time under PFML, unlike FMLA, can be intermittent. Under FMLA, you might remember it's only with the employer's approval can leave be taken intermittently for bonding. PFML employees have the right to take it, in whatever increments they want, as long as they're taking at least 8 consecutive hours in a given week. And then any hours above that would be covered PFML. There's also another coming amendment that creates kind of a limited bereavement leave in the event of a death of a child. So a baby for whom the employee could have taken medical leave, like if there's a miscarriage or something like that, or if there's an adopted child that passes away, up to 7 calendar days would be covered by PFML. And then we have those military qualifying exigency leaves, same definition as under FMLA. So those are all of the covered reasons for taking PFML. Leave entitlement duration, again, looks kind of like FMLA, but a little different. So it's 12 weeks of family leave or 12 weeks of medical leave or a combined total of 16 weeks. And then an additional 2 weeks if the medical leave involves pregnancy-related incapacity. Again, intermittent leave is available under PFML and can be taken intermittently for bonding. There is a waiting period. So the person's entitled to leave, but they wouldn't be be entitled necessarily to the state benefits for the first 7 days. And it runs back from the Sunday before they filed the claim. That would be their 7-day waiting period. So, and there are times when the waiting period doesn't apply. So that's just kind of background information. I think this slide is kind of a helpful reference point, just kind of pointing out the differences between FMLA, or, similarities and differences in terms of duration. The family member list is broader under PFML, the intermittent bonding leave difference, the, unpaid versus partially paid under PFML. There's no limit, under FMLA, we had the limitation for spouses employed by the same employer. That doesn't exist under PFML. The claim year, under FMLA, we've got different claim years, including like a backward-looking one, look-back method. Under PFML, it's a forward-looking 12-month period, from the day they file the claim generally. So those are kind of just a reference for your information about how those relate to each other. Common question that we got, because everybody, I think, kind of got whipsawed on this one. Everybody thought that PFML and FMLA would run concurrently, right? It just converts FMLA into, the option of being partially paid, right? So we really didn't think that FML or PFML would be that big a deal, but it has become so because there are a number of situations where PFML doesn't necessarily run concurrent with FMLA. One common reason is maybe somebody's I'm taking leave from my grandma, right, to care for my grandma. That's covered under PFML. It's not covered under FMLA. So I haven't used any FMLA. I still have 12 weeks of FMLA despite taking 12 weeks already of PFML to care for my grandma. Or if I have a workers' comp injury, I might use my FMLA, but I'm not eligible for PFML. That means I have all of my PFML left available. And then I think the big one that caused a lot of surprise and frustration for employers is that the PFML leave clock does not start running until somebody files a claim for PFML benefits. So obviously PFML isn't running concurrently with FMLA if the employee doesn't file the PFML claim. So the employee gets to, stack the two depending on when they file their PFML claim. That, I think, was kind of the biggest surprise and disappointment for employers who didn't realize what the effect of this law might be. Some interplay with other leave and benefits. I mentioned you can't get workers' comp at the same time as PFML. You also can't get unemployment benefits. Health insurance obligation under PFML. The statute says if it's required by the FMLA, the employer has to continue health insurance during PFML as well. That to me seemed pretty straightforward. If FMLA is exhausted, you wouldn't have to keep maintaining their health insurance because it's not required by FMLA. ESD passed a regulation that said if FMLA and PFML overlap by even a single day, the employer must maintain health insurance during the entire duration of PFML. So that's, we tried to argue with them about that's not what the statute says, but that is the regulation that was adopted. Sick and other accrued leave, it's up to the employee whether they, it's up to the employer whether you allow supplementation with accrued leave. And then if you do, it's up to the employee to decide whether they actually want to use the accrued leave to supplement. So kind of two layers of questions there, decision points, first for the employer and second for the employee. This slide just kind of again underscores that when we have a particular leave entitlement, we're looking at multiple leaves that may be in play, leave laws that may be in play. So this, first example is the wife of your employee needs to have surgery. What laws are we thinking about? Yes, FMLA potentially. Yes, PFML could be available. Washington Paid Sick Leave, Washington Family Care Act. If we're talking about the employee's own serious health condition, then we're talking about still FMLA, PFML, Washington Paid Sick Leave. Washington Family Care Leave is out of the picture because that's only caring for family, but we have ADA and Washington's Law Against Discrimination, disability accommodation that may be in play. So we're going to have, as we'll talk about in just a minute, some overlapping considerations and laws that might provide multiple layers of protection for somebody. So that's a good segue to some of these leave scenarios. So I took a bunch of different scenarios, just, okay, let's assume that your employee, female employee has a baby. How might these different leave entitlements apply? And you'll see it really can kind of depend on the circumstances and on various choices that the employer and employee make throughout this process. So employee A, first example here, involves an employee who right out of the gate applies for PFML. She wants PFML benefits immediately from the point of birth. And in this case, we have an employer who decides we're going to designate, whether the employee wants it or not, we're going to designate this as FMLA also. Or maybe the employer doesn't do that, but the employee wants health insurance. So they have to elect FMLA, right? Because PFML doesn't require continuation of health insurance unless FMLA also requires it. So in this particular case, we've got FMLA running concurrently with PFML, and then pregnancy disability is in the picture, but it really doesn't change anything because you've got an FMLA eligible employee. She's already protected by FMLA and PFML. So pregnancy disability is running, for presumptively for 6 weeks, but it really doesn't change anything. The question of other accrued leaves and whether they would be in play here depends on the employer's policy. Do you allow supplementing of PFML benefits with accrued leave? If so, you're going to also see, maybe some accrued leave being used along this timeline. But under this scenario, an employee can get to 18 weeks of protected leave and would have PFML benefits. If the employer doesn't allow supplementation, she is going to have her entire leave banks available to her at the conclusion of that 18-week period because she hasn't used any yet. Okay, so then we get another one where in this situation, PFML and FMLA run consecutively. Let's say the employee requests PFML right out of the gate, applies and files a claim, and then doesn't want FMLA, and the employer says, oh, we're going to follow a SCREBA. We're not going to designate FMLA over the employee's objection. So she takes her 18 weeks of PFML, gets benefits during that time. Note that she's not going to get health insurance during that time, maintained by the employer, unless you allow that. The law doesn't require it if she's not on FMLA. It could be in the picture. Let's say you allow supplementation. So this employee is using accrued sick and vacation or PTO during PFML to supplement. And depending on your benefit eligibility for health insurance, maybe she's using enough to maintain her health insurance. So that's a way it could, the health insurance might still be covered during that first 18 weeks. So then we run out of PFML at 18 weeks. She turns around and applies for FMLA and has that, another 12 weeks of protected unpaid time off. But let's say she's got vacation that she's using in that. This example, has her not using her Washington paid sick leave, because remember, we can't force her to do that under FMLA given the L&I position. So she saves this extra bucket of 6 weeks of Washington paid sick leave. She would have to be sick or have some kind of health condition. So I just threw in, let's say she's got postpartum depression at that point. So that gets us out to, through this different combination of leaves entitlements out to 36 weeks. So that's another just example. Again, these are just different ways these leave situations might unfold depending on employee choices and employer policies. This one is where FMLA and PFML run consecutively, because the employee delays PFML. So she doesn't want PFML. She says, no, I'm just going to take FMLA first, but I'm going to use my accrued leave to get, paid during my FMLA. Yes, it's covered by pregnancy disability, but so what? Doesn't really change anything. Then she gets out of FMLA, and she's smart enough to know that the day before FMLA runs out, she files her PFML claim, right? And that way we have to maintain health insurance during the entire PFML period. Because of that overlap. Now note that in this situation, she's probably only going to have 12 weeks of PFML because she doesn't need medical leave. I'm guessing after 12 weeks, she's probably not still disabled by pregnancy and childbirth. So at this point, she's limited to the 12 weeks of family leave under PFML. So it would be paid and protected under those circumstances. All right. And then this one, I just wanted to illustrate again, the PFML can be taken on a bonding, like intermittent bonding. So in this particular example, the employee elects to use her FMLA first for the first 12 weeks. And she uses her accrued vacation and sick leave to maintain her pay during all or some or all of that FMLA. Then when she comes back, she says, but I want to take PFML intermittently after I complete my initial 3 months, 12 weeks of leave. So, I mean, I have these little green bars to show she's taking it over time. It could be a day or two here. It could be 2 weeks there. I mean, she's in control of that usage. But as you can see, it could go out for the entire claim year under PFML. Benefits would just depend on the employer policy in terms of eligibility. Is she in paid status enough to maintain her health insurance during that? Probably, if she's only using it intermittently. And then this last one is, let's say we have an employee who's not yet eligible for PFML or FMLA for job protected leave. So in this particular situation, let's say she's only worked for you for 8 months. So she's not entitled to the protected leave. So this is an example where that pregnancy disability would be relevant, right? So she's presumptively disabled for 6 weeks following childbirth. So that's job protected leave. She can apply for PFML during that and get those partial PFML benefits as long as she's worked 820 hours. She's not getting job protection under PFML, but she doesn't need it because she's disabled by pregnancy and has that protection, but she can get the monetary benefits. Then after 6 weeks, she converts to Washington paid sick leave. She would have to have some covered reason for using it, but let's say, you know, that continues to be protected and she's out for a Washington paid sick leave covered reason. Then she runs out of sick leave. She could say, I'd like to take more PFML. Now at that point, again, she still has monetary benefits available through the state. The leave is not necessarily protected. So she would have to, you know, request that from the employer, and it would be up to the employer to decide whether to approve, you know, protected or offer leave in that situation. So again, just a different example depending on eligibility standards and the employee's choices. Wanted to also mention, I alluded to this early on, but as we run out of FMLA and paid family medical leave, we have to transition if somebody's still out for their own medical condition, health condition, and they need more leave. They're not able to return to work yet. We have to be thinking, you know, put on our ADA reasonable accommodation hat and say, okay, how much additional time we're going to be talking with their provider, engaging in that interactive process to decide how much additional leave is needed and what can we absorb. At least now we're talking about, would this be an undue hardship? It's a case-by-case assessment. Unfortunately, I can't say this is reasonable and this isn't. Other than I can tell you that indefinite leave, I don't know if or when I'll ever come back. That's not reasonable. But anything short of that, we need to say, okay, what does this employee do? What is the hardship? How hard is it to cover their work if they were out for an additional, you know, whatever? And it really depends on the operational burden that we can articulate. Certainly, if somebody's been out, you know, and they only need a 2 more weeks, I think it might be hard to show that that's an undue hardship. But when somebody says 3 to 6 months or 6 months or more, that becomes more, you know, easier to establish an undue hardship. So kind of case-by-case assessment on this. It depends on the job. It depends on the workplace, et cetera. Maybe somebody comes back and says, well, I need work hardening, you know, I need to transition back and start working 4 hours a day, you know, initially. That might be a reasonable accommodation. Generally speaking, you don't have to create a permanent part-time job for somebody as an accommodation unless you already have part-time jobs, you know, in that category, in that job class. But generally speaking, we don't, if it's an essential function to work full-time, then that wouldn't be necessarily an obligation. There's a good EEOC guidance document on leave that just kind of has different fact patterns and scenarios. I have the link there. It also addresses, and I just wanted to mention these briefly, those maximum leave policies. Like some contracts and personnel policies will say, you know, we're so generous, we grant up to 12 months of protected leave for an employee's medical condition. But if you're not fully released on the 366th day, you're administratively terminated. those are risky, and the EEOC addresses this in that link there. The EEOC still wants us to go through the interactive process. If somebody wants 1 week beyond that 1 year, you have to show that's an undue hardship. You're going to get credit for the fact that you've already given a lot of leave, but we can't just reject it out of hand because it's an hour or a day or 3 days or 1 week beyond, our maximum leave policy. So we still have to kind of go through the process of considering the extent of hardship and our ability to absorb the requested absence. So one more sample leave scenario as we're getting close to the end here. Involves a non-pregnancy situation. So in this particular fact pattern, we've got an employee who was injured on the job, and it's a serious injury. So let's say he is unable to work, right out of the gate, and he's going to be off for like a year. So that whole time he's getting L&I time loss benefits. Remember that L&I is not a leave law, right? So the right to be away from work, even if it's an on-the-job injury, comes from FMLA, comes from ADA accommodation. So the fact that that red bar keeps going and L&I keeps paying him workers' comp time loss benefits doesn't necessarily affect our obligation as an employer to approve leave for that individual. So we want to immediately, when he's unable to work, we want to place the individual on FMLA. Again, some of you have labor contracts that say, oh, we don't do that. First, we provide this other leave. Technically, Department of Labor says you should, but you need to obviously manage your existing policies and practices. But generally, we're going to put somebody on FMLA from the outset of their absence. So that's 12 weeks initially of job protected leave. Then he gets to the end of that 12-week period. I don't know whether the employer here has policies or labor contracts that give the employee more, but let's say no. Our legal obligation in that situation is to consider reasonable accommodation. So here, after 12 weeks, we reach out to the employee, are you coming back? What's your plan? What do you need? The employee's doctor says, he needs 4 more months of leave. And so we might say, can we do that? What would be the hardship? We look at it and we say, okay. And that blue bar, I don't want to leave you with, that's the right amount of ADA leave, because it really depends. It could be a lot shorter if this is a critical position and then you're just dying while this person's out trying to cover their work. But let's say in this situation, the employer approves leave out to 42 weeks, but beyond that really can't absorb it any longer. It's becoming an undue hardship. And so at that point, you may medically separate. And again, the employee may continue to be eligible for time loss benefits if they can't work, but they don't have the job protection at that point. So you might go through the medical separation based on undue hardship. So that's kind of an example of how that would work. Under the FMLA, you would keep the benefits intact. Under ADA, you don't necessarily need to. That would be a function of policy. Maybe they go on COBRA. Okay. We touched on this in one of the questions earlier, kind of leave rights related to COVID. And I mentioned potentially a COVID-related absence could be covered by FMLA and or PFML if it rises to the level of a serious health condition. So it depends. It also could be covered by Washington paid sick leave or the Family Care Act if the employee is caring for a child, for example, who has COVID. So that those might be implicated. The other law that we need to be mindful of is this high-risk worker leave. We started in the pandemic with a governor's proclamation about this, and then it was changed last year to a statutory. It's called HELSA. What's it called? I can't even remember. Labor Standards Act. HELSA. One of the things that HELSA did was to say that an employer has to provide accommodation, safety-related accommodation for high-risk workers. And those are workers who basically are at higher risk if they contract COVID-19. And you can see the categories there: older adults, pregnant people, or those with certain medical conditions, and they're listed there. So if somebody is in a high-risk category and they say, I can't come to work, I need to work remotely, we might have to say, okay, are there safety accommodations at work or allowing them to work remotely that would avoid this kind of undue risk? And if not, let's say we've got a bus driver or we've got a lifeguard, they can't work remotely, they can't work at all if they can't be physically present. And so then this law says you have to allow them to take a leave of absence. They can use their accrued leave, they can use, they can get unemployment even, and we can't replace them. We can't like say, sorry, undue hardship. And this obligation is for the duration of the public emergency. So we're kind of wondering if this is going to come to an end at some point soon, but I just haven't heard any rumors. So if anybody has heard rumors, weigh in on the chat. There's an L&I document, kind of Q&A on HELZA, and this slide kind of goes through more specifically some of the obligations, right? Are there safety accommodations? If not, then you look at leave entitlements. You can require medical verification to confirm that somebody is in a high-risk category, not what their diagnosis is, but are they in a high-risk category? And then go through your, use your normal accommodation process to explore options with them. Again, this may be, could be while we're in this session that the governor retracts the public health emergency. I don't know, but watch for that, because I talked to somebody this week whose employee has been out since early 2020 as a high-risk worker. And there's really nothing they can do because the employee can't remote work and they can't replace this employee. So very, very long standing leave entitlement. Okay, this winding down here, so I'll certainly open it up to questions in a moment or two. I just wanted to leave you and impress you with the general confidentiality requirements under FMLA and ADA, really anything related to employee medical information. Please make sure that you have appropriate protocols to maintain the confidentiality of that information. Make sure supervisors know that if somehow they become aware of medical information, that they don't share it with anybody else. And sometimes that is a natural thing. Oh, they're out because no, you can't do that. So making sure that your supervisors are well versed on those confidentiality requirements. I wanted to mention HIPAA because we often hear, especially employees, HIPAA, you can't ask me that, or I can't, you're not entitled to that. HIPAA really doesn't regulate employers. It regulates the providers who can't share information unless the employee signs a release. But we can require things like an FMLA medical certification, or we can condition, we're not going to consider an accommodation request unless you tell your doctor to talk to us about what's going on and what you need. So I just threw that out because I think it's a kind of a misunderstood entitlement that an employee will, chirp about HIPAA. Okay, so I think that is, obviously I want to just underscore annoying but necessary notifications that, this information, a couple of things here is, as I said at the outset, the laws change rapidly in this area. So this is kind of information as of today, and it might change with further developments in the law. And I'm not trying to answer specific legal, this isn't like attorney-client privilege legal advice. So if you have kind of a complex scenario, please make sure you're talking to, your HR professionals or legal counsel to get specific guidance about the particulars of your situation. So with that, we're back to our maze, and I will check and see whether there are questions that I can address. Okay. Gosh, let me make sure. Oh, where did we leave off? Okay, I think this is where we're. Okay, does Washington paid family leave transfer to a new employer if an employee has been approved with their prior employer, or does the employee need to reapply for leave with a new employer? So I mean, I assume, I haven't looked at that. That's an interesting question, but I assume like if you have just hired a new employee and they were approved for PFML with their prior employer, they're new to you. So they may still be entitled to the monetary benefits because they've worked 820 hours within the state of Washington. But I would not think, I can't imagine that somehow they're still entitled. If they change jobs, there's still the eligibility requirement that you're not required to provide job protected leave until somebody's worked for you for 1,250 hours or 12 months. So I haven't looked at that specifically, but I would be very surprised if the new employee had leave entitlements if they didn't meet the eligibility for job protected leave by working for you for 12 months. I hope that answers that. I'm gonna go check, but I don't recall seeing anything that would require the new employer to provide leave in that situation. Okay, next question. So if you are scheduled for overtime and you call in sick, you can still get paid overtime and take sick leave for it. Same for mandatory overtime. Yeah, I think so. I mean, yes, you're entitled to get sick leave if you're scheduled for overtime. What I'm not totally sure is, I would need to check whether it would be paid at the overtime rate if you didn't actually work, or is it at your sick leave rate? If we're going to do questions after the fact through the platform, I'll try to make a note and answer that question in any kind of follow-up. I feel like I knew that back in 2018 when the law was enacted, and I haven't been asked that since, and I can't remember. My sense is gosh, now that I'm mulling this, my sense is you're entitled to get the compensation you would have earned had you worked the time. I don't want to leave anybody with the wrong impression, so I'm going to say I need to check that, and I'll try to include that in any follow-up. So thanks, Nicole, or Jennifer. Okay, can an employee use their own leave time for the 7-day waiting period, or does it have to be leave without pay? Yes, you should allow an employee during that 7-day waiting period under PFML where the employee is not entitled to use, or they're not entitled to receive PFML benefits. You should allow them to use their accrued leave. Certainly, they have a right to use accrued Washington paid sick leave if they're out for a covered reason, which they almost certainly would be. So they would certainly have that right. But I would think you would, if they're out of that, or, it's PTO or vacation, you would probably allow them to use that. So it doesn't have to be leave without pay. Next question. If an employee is using intermittent PFML during their approved time period, does that have to be in 8-hour increments? E.g., if they have to take 8 hours one day and 4 hours the next day, does that deduct 16 hours from their available, or 12 hours? So the only requirement is that somebody take at least 8 consecutive hours in a work week in order to file a claim. Once that has been satisfied, they can take additional PFML hours in any increment. So it would be, in this example, if they took about 8 hours one day and 4 hours the next, they've only used 12 hours of PFML. But they couldn't do like 4 hours on a Monday and 4 hours on a Wednesday and 4 hours on a Friday. That would not allow a PFML claim for that week. But it does not have to be in 8-hour increments. Just that first, there has to be at least one 8-hour nut in there of consecutive 8 hours to support a claim for the week. And then again, any additional hours could be taken in incrementally. Okay, how is PFML 18 weeks for the birth of a child? Well, it's because we get 12 weeks of family leave and 12 weeks of medical leave, or a combined total of 16 weeks if you take a combination, but up to 2 additional weeks if the employee has a serious health condition that involves incapacity due to pregnancy. So in a situation where an employee is pregnant, has a baby, she's got the max, because she's taking both medical leave and family leave, gets up to 16 weeks, but because she's got pregnancy incapacity, she gets the additional 2 weeks. Now, I will say, when I went to the state website, it talks about the additional 2 weeks being due to pregnancy complications. But if you actually read the statute, it's a serious health condition that involves incapacity due to pregnancy. Well, I mean, a serious health condition is inpatient treatment. So she was in the hospital to give birth, and she's obviously incapacitated. So I haven't actually seen a situation where ESD has directly addressed whether there has to be some complication in pregnancy to get up to 18 weeks. But if I just read the statute, this is an area, I mean, from my perspective, ESD bends backwards to be more generous in every interpretation of this law. So I would be shocked if they said, that a normal pregnancy incapacity doesn't get somebody to the 18 weeks. But you get to 18 weeks because you combine both the 12 weeks of family and the 12 weeks of medical, and get up to the combined total of 16 plus the 2 for pregnancy incapacity. Sample slides, you're welcome. Unpaid FMLA can run concurrently with an employee using some paid time off at the same time as in one of the earlier slides. Unpaid. Yes, I mean, FMLA is unpaid, but you can require, and an employee has a right to use their accrued leave during an FMLA. So yes, absolutely, FMLA is going to usually run concurrently with use of accrued leave. That's probably a function that's addressed, or a function of your personnel policy that says you're required to use your accrued leave during an FMLA leave, or at least you have the option to do so. So yes, definitely. Can an employer require time loss benefits are reimbursed to employer by employee if they use accrued leave during time off? Okay, wait, sorry. Can an employer require time loss benefits are reimbursed to employer by employee if they use accrued? Oh, and then, yes, you can have a kind of a buyback system. So this is more of a workers' comp question. So there's a lag, right, with time loss benefits paid out by L&I. So you can have a situation where we allow an employee to go ahead and stay in fully paid status by drawing on their accrued sick leave or their accrued vacation. And then when they get the time loss check from L&I, they basically turn that over to the employer to replenish their leave banks. And so it pays the employer back for the sick leave that's been paid out, and then, brings their balances back up. So yes, you can do that. It's very common for employers to do that. Can you talk about Washington paid sick leave and how employees have to be paid what they would have made on their shift, like a differential? This goes back to kind of that overtime question. And if somebody calls in sick during a mandatory overtime shift, how much compensation do they get? I need to go back and read this, but I provided that link to the Washington paid sick leave FAQs that L&I put out. That's a lot of letters. And it's a Q&A, and it goes through those questions. There's also a regulation, a WAC, that talks about that. I will tell you, it's not a model of clarity. The general rule is that they're entitled to get paid what they would have earned had they worked, if they use Washington paid sick leave, or at the rate had they worked, if they use Washington paid sick leave. But there are some kind of caveats to that. And I would encourage you to look at the FAQs for that. And if they're not clear, then we can certainly circle back through the platform Q&A to address that question. If there's like a specific, I think the answer depends on what kind of premium or differential we're talking about. Okay, did I understand correctly? But Washington paid family medical leave is job protected if they work 12 months and 1,250 hours. Yes, so they could take FMLA January through March, and then July, if they have 12 months and 1,250 hours, they could have job protection again. I'm not, so I think the answer is yes. Like, I think this is an example of taking FMLA and PFML consecutively rather than concurrently. So yes, somebody could take FMLA January to March, so 12 weeks for something, medical leave or family leave. Then they come back to work, and in July, they could file for PFML. They have no more FMLA left because they ran out of it, but they haven't used any PFML. And then they could file a PFML claim. And if they've worked the 1,250 hours at that point, they would be eligible for their full PFML entitlement. So yes, they could have job protection again. I think that's that question. Would it be mom had a C-section? I think that's a reference to the pregnancy complication or pregnancy, the period of incapacity. I mean, again, I think that there's a presumptive period of disability following, even a normal non-C-section childbirth. So I guess I would just be surprised if ESD takes the position that that does not entitle somebody to the additional 2 weeks, getting them up to 18 weeks. It certainly meets the statutory definition, because you would have a serious health condition by having birth, being, inpatient treatment for birth and a period of incapacity afterwards. And I think that meets the standard for those extra 2 weeks. Our employee received an additional 2 weeks due to their child's health complications. Well, that's interesting. I can't, I can't always, I wish there was kind of some central hub where employers could share information about what, ESD did in particular situations. I think that would help all of us. There used to be, when the statute was first enacted, a forum where people could ask questions and share information, but they pulled that down. Yeah, I don't know how, I mean, it's usually the extra 2 weeks should be associated with a period of incapacity. So I don't know what the additional 2 weeks do the child's health complications unless they just still had, available PFML for that purpose. So, okay, I think we've gotten to the end of our questions. Thank you, Jerry. And I will stop talking and let Bobby come back on.
Wow, Kristen, you might want to take a breath. That was a great presentation. And I mean, there's a lot of information that you gave to us, and important information, because obviously the laws are a little bit complicated and it's a lot of information to ingest for all of our folks. So thank you so much for being with us today. We really appreciate it. And we wish you continued success with Summit Law.
Thank you very much. Thanks for having me.
Thank you. Okay, well, guess what, folks? We have made it through 2 days of the Benefit Summit. We've had some great meetings together. We're about to wrap this up very quickly. I want to say thank you once again to all of our presenters. I want to say thank you to everyone that has attended our summit. I want to encourage you, and Janae will probably talk about this in just a moment. I want to encourage you to take the survey at the end of the presentations today. Let us know what you thought about the summit. How we can improve, how we can, what do we need to do next year? And as we've been talking about, we're looking at the possibility of getting back in person, which we, our initial responses from folks are letting us know. So yes, we would love to be able to be back in person next year. So we really want to look at that. We appreciate our sponsors, and I especially want to thank all of our staff here. And most of all, Janae Cargill and Shauna Zuzikov are doing such a great job. So I'm going to step out of the way. Again, thank you so much. We're excited that you were able to be here with us, and we hope that you had not only an informative time, but a really great time just spending time with WCIF. And I'm going to turn you over to Janae, and I hope everybody has a great weekend and go get some rest.
Thank you, Bobby. So just a few quick items, you guys can get back to your day. So just a reminder, the bingo sheet, please send that to Shauna at WCIF.net. And if you had a blackout, so if you crossed off all your squares, that's an additional raffle. And then each bingo that you get, so horizontal, vertical, and I think 4 corners, I'm not sure, that gives you another entry into the raffle. So send those to Shauna. And then the swag too, just send another email to Shauna, or just include it in your bingo sheet one that you'd like to be entered into the raffle if you missed the deadline to receive a swag box. Let's see. And then Monday, you can expect an email from Shauna that will include the reimbursement form for your lunches for both days. If you ended up purchasing a lunch, we will reimburse you for that. So $40 total, $20 per day. Bobby already mentioned the post-meeting survey. You'll find that in there as well. However, I would encourage you to access the survey through the Whova app underneath resources within the documents tab. I've found that if, while it's fresh in your mind, that's a great time to fill out the survey. So up to you, but you will get it in the email Monday. And then I think I mentioned this earlier, the Q&A questions through Whova. I know a lot of us are using Zoom as well in conjunction with Whova, so we're not able to see the questions from there. So we are going to send those to all of the speakers, and once we have all the answers, we will share those with you. Let's see. So I think we had another chat here. Okay, maybe not. Anyways, thank you, everyone. I hope you enjoy the rest of your day, and we look forward to hearing back from you.